Good evening, everybody, and welcome to the very first In Conversation live from the RSM of 2021, a year that looks to me to be a very eventful year. COVID impacted massively. Well, we're very lucky this evening to have a very distinguished lawyer to talk to us about medical ethics and about patient safety. I think most people will know the name of Sir Robert Francis. Born in April 1950, British barrister specializing in medical law. His Wikipedia entry is so long that I haven't got time to read through it all. But I think most notably, he's been involved in all sorts of investigations and inquiries into, for example, the Mid-Staffs disaster and a lot of other things that we'll be discussing today. I'm proud to say we've got 1,500 people registered to watch this, and you can, of course, send in your questions, although I'm sure we won't get time to answer all of them, but I promise you we will look at all the questions that you send in and we'll analyze them very carefully. So Robert,
good evening.
Thank you so much for your participation. Let's start off with COVID, and let me ask you that, we're facing a crisis. We've got unprecedented level of deaths today, more than 1,000 people dying. We've got ITUs overflowing. My friends in St. George's and Bart's and Guy's are telling me that the overflow situation. So, I mean, there are medico-legal issues here, and I know a lot of young doctors who have been drafted in to deal with this crisis feel, vulnerable from the medico-legal point of view. So what's your comment on that?
Well, I'm not surprised they feel vulnerable, and we must be very grateful that they're stepping up to the plate in the way that they are, both those who are regularly in the system and employed and those who are volunteering to come back. My general feeling is that they shouldn't be over worried about being sued for various reasons. One is clearly the NHS would pick up the tab if they were. Secondly, in an emergency setting, the scope for making mistakes is sort of more understandable. It is likely that were a case to be brought and after a mistake had been made, I think most courts would be very sympathetic to the circumstances in which judgments have to be made very quickly. So I think the bar for having a successful action will be high. There is the issue about disciplinary cases, which worries a lot of doctors. I would expect the regulators, both nursing and medical, to be very hesitant to bring actions or proceedings against doctors in these very fraught circumstances. It will be entirely counterproductive in almost every case. So, short of really egregious stuff like people turning up drunk or whatever. So I understand the fears, but I would very much hope that particularly junior doctors are receiving support from their more senior colleagues to allay those fears.
Yeah, well, just tell me a little bit, we were discussing when we prepared this program about your career and why you decided to opt for medico-legal practice as opposed to commercial law, which is maybe better rewarded financially.
Yes, well, when I started a very long time ago at the bar, far too long really, in periods that are now seen in history programs. And when I started, there wasn't really such a thing as medical law. And what I started doing was what most people did who weren't going into commercial law, which was general common law. I used to tour around the Western Circuit doing criminal prosecutions, divorces, small contract cases, and so on. And after a few years of doing that, it just so happened that one or two cases, in fact, General Medical Council cases, came into my chambers. And one or two of us found those far more interesting than everything else we were doing. So we started to concentrate on that, and we got more cases as a result. In those days, it was almost impossible, not absolutely impossible, but almost impossible for a patient who'd been the victim of negligence to actually get an action off the ground, because I'm afraid it was almost impossible to find a medical expert who would be prepared to testify against colleagues. Those that were brave or bold enough to do so were often actually ostracized by their colleagues. Some were castigated for being mad and all that sort of thing. That, of course, changed over the years, and it became easier for justice to be done for people who had been wrongly treated, if you like. And so more work came in. Now, why did I do that rather than any other form of work? Well, actually, as it happened, a very esteemed member of my chambers, not recently, quite recently died, actually specialised in building work, and he did persuade me to do a little bit of that because, as you say, it was better paid than anything else I was doing. And I'm afraid I found it so boring and so removed from anything about people that I really couldn't stand it. And so I went back to medical work, which I have to say, by most people's standards, is not badly paid. But I actually find the interest there in the people, both on the patient side and also the excellent professionals I have the privilege of meeting, or have had the privilege of meeting, both as clients, as witnesses, and also as experts. And it's the interaction between a profession and those the profession serves, which interests me very much indeed. And being a member of a profession of my own, and that's what interests me about it, and why I continue to do it. Probably some would say for far too long.
I don't think so. I think we're going to be talking a lot about the patient's point of view and your role as chairman of Health Watch and president of the Patients Association. But already some questions coming in, and I can tell that this is going to be an issue. So we maybe start off with Professor Kapoor saying, what's your solution to victimization and bullying still rife in the NHS, with BME staff often suffering most? And then Salam Aslam says, Sir Francis, many committed and caring doctors believe that doctors who whistleblow on bad practices are not really protected. So some thoughts about that, about bullying and about whistleblowing.
Yeah.
I know that they're in subject.
It's a huge issue, and Narinder Kapoor, if I may say so, has been at the forefront of advancing the cause of doctors, some of whom have suffered egregiously as a result of victimization. And there is a wide degree of disagreement about the way forward. And I was asked by Jeremy Hunt to review what I just wanted to call the freedom to speak up in the NHS rather than whistleblowing, because whistleblowing has a sort of pejorative note to it, and which I think is part of the problem. And what needs to happen, and what I thought needs to happen, is a complete change of culture in the NHS towards people who, in good faith, raise concerns about what is going on in the place where they work. And too often in the past, when people have done that, they get ostracized, they get singled out so that they're on their own. They become, because they know they're right, and I can say sometimes in brackets, even if they're not, they know they're right. They persist and persist because it's in their conscience to do so, and they suffer. Some lose their jobs, some have nervous breakdowns, some feel suicidal, and that's just not right. In order for the NHS to be a safe place for patients and indeed for staff, it's got to be a listening and caring organisation where people who raise concerns in good faith are treated with respect, that their concerns are looked into rather than excuses found to vilify them, and something done about what they have to say. And then they should be thanked for raising whatever it was. Now, not every time someone raises a concern are they right, but if it's found that there is no substance or in what has happened, or if there is a means of dealing with it which the individual hasn't agreed with, that's got to be explained. And there will, of course, come a time when there has to be an end to the discussion and people move on. But that only works where there's an atmosphere of trust and so on. So that's what you need. And we're in some places, I believe that now exists. But and what I thought needed to happen was that the raising of concerns needed to be absolutely normal business as usual in every bit of the NHS, whether it be the cleaner or the senior surgeon who had a concern about colleagues, about the way things were done. They should be able to raise it in any way really they wanted to and get a hearing. And if they don't get a hearing, then that's where the problem is developed. So what I suggested was that every NHS organisation should have a system of guardians, freedom to speak up guardians, who would be respected people in the organisation, not necessarily senior at all, but who would have the ear and support of the chief executive, the board, but also respected and trusted by staff, so that people could go when things weren't going well in this regard. And they would not fix the problem, but would actually make sure that people were being listened to and weren't being castigated. Now, it's taken a long time to get that going, but every trust now has these guardians. Many have networks of ambassadors for people to go to. There is a National Freedom Speak Up Guardian. And I believe the very existence of this network is making a difference. Every year, more and more concerns are raised through the guardians. Many of them are about clinical safety issues. The National Guardian has undertaken reviews of the way in which whistleblowers are treated in a number of different trusts and produces recommendations about that. So we've got the beginnings of it, but I absolutely understand the anxieties of many people. There probably needs to be more done. And one of the things that I think more needs to be done about is that when eventually an aggrieved whistleblower, and I will call him a whistleblower for these purposes, goes to an employment tribunal because he's been sacked or whatever, and wins his case, I think there should be accountability for what has happened. I'm afraid at the moment, the employment tribunal is saying really strikingly alarming things about the leadership in some trusts, but nothing much seems to happen about the attitude of that trust towards someone who has raised these sort of issues and has had to go to the extent of going to an employment tribunal to get a remedy. So I think there needs to be a greater sense of accountability. My proposal at the time of my review about that was to examine the conduct of leaders through the fit and proper person test, which is administered by the Care Quality Commission. But that was recently reviewed by Tom Cott QC, who was in fact had been counsel to my inquiry at mid-staffs. And he made some very sensible recommendations in this regard about changing that system. And I think those ought to be looked at seriously and urgently. And the final thing I'll say, I've been speaking too long on this, is that there are people who have not received justice through the current system, either through employment tribunals or elsewhere. And I think there is a gap. There is a gap in the system in relation to providing a remedy, proper remedy, for people who have suffered egregiously because they, in good faith, raised a concern and they've suffered as a result.
Well, that's an answer I think that's going to resonate with a lot of our viewers, listeners. Richard Nicol, he kind of leads on actually to a question of Richard Nicol. He said, how do you feel when you make about 80 plus recommendations in your Francis report from mid-staffs and then they're not implemented? And I suppose a sort of corollary of that is, you know, if whistleblowing was more widely adopted earlier on, maybe, do you think that might have avoided some of the problems at mid-staffs? Let's talk about mid-staffs, because
he's kind to say it was 90 recommendations. In fact, I made 290 recommendations, in fairness, most of them were accepted. In fact, virtually all of them were accepted by the government, and something has been done about most of them, but obviously a lot more could be done about some. So I'm not proprietorial about how things are done, but the acceptance of those recommendations was something of a triumph at the time. It's always a problem with reports. I mean, my report made recommendations very similar to those that Professor Sir Ian Kennedy had made after the Bristol scandal. They're very similar to recommendations made since by Dr. Kirkup in relation to the Morecambe Bay disaster. And the Ockenden review this year also contains some stuff which I suspect will echo that. So there is a problem about translating the findings about problems, which almost everyone agrees what the type of solutions are, actually getting change. And the challenge is that the NHS is, I always think of as a completely different country. Actually, it's as big as some states. It has the budget for more than many developing countries. It has its own politics. It has its own social groupings. It has its own conflicts of interest within it. And then within that, every trust is slightly different. So trying to pull levers to get change is very difficult. And actually, I'm convinced that the only way universal change will happen is actually, and it's often said from the bottom upwards, it's the staff who can change things, and with patients supporting them, rather than expecting the benighted Secretary of State, who has very few levers, funnily enough, to deal with this. Change needs to happen locally, and it needs to develop upwards, and good practice needs to be developed all over the place. But that requires those who lead organisations to empower and listen to their staff. And I'm not talking here about terms and conditions, I'm talking about how things should be done. And there also, the counter to that is that there needs to be a degree of standardisation, and I think the professions need to step up to the plate, and I think they have been, in terms of expecting more standardised practice about all sorts of things. But we still have pockets where everything has to be done my way, not the way someone else does it, and I think there are problems around that. But generally speaking, what I found in mid-staffs was there were problems developed because people just assumed that what they were doing was safe. They assumed that they were being caring when they weren't. And the pressures from outside, from, in that case, targets, staff cuts and so on, were such that everyone concentrated on process rather than the reason for that process, which was the benefit of patients. So I know that's a slightly waffling, slightly generic answer, but I do think that, again, the answers are cultural, but actually hard steps need to be taken to change culture. And I think you'll find in the really successful places where medicine is administered, that culture has changed, but there are still, of course, pockets where it hasn't.
Well, Adrian Farrell says in 2010, he worked in a trust where the director of medicine commenting on the emerging story from Stafford, and I know you spent 2 years up there doing that investigation, because that's when I first met you, Robert. He said that there go us, but for the grace of God. I mean,
that's true. I have had to explain on a distressing number of occasions to politicians, and I went, but at a reasonably high level, that mid-staffs wasn't a one-off, and I think we know that beyond doubt now, because look at the Morecambe Bay report this year. If you look at the Ockenden review about Telford and Shropshire, you look at what's being reported about East Kent, just to give you 2 examples this year. Now, a lot of the cases, to be fair, that are looked at in those sort of reports are old and probably predate mid-staffs in many ways. But I'm afraid the attitudes are still prevail in some places. And I think, I would like to think that something as wide-ranging as mid-staffs will be difficult to happen now, not impossible. But I think you'll find departments in hospitals where there's a sort of mini culture that is allowed to persist. And then there are some themes that go across the system, and one of them would be, I think, in maternity services. I think increasingly we're seeing evidence that there is a cultural divide between midwifery and obstetrics, which needs to be cured, because unless those two literally work hand in glove as professions, I'm afraid mothers and babies, or some of them, are going to fall through the gaps. So that's an example where things need to change, and change very rapidly.
Well, my friend Sir Marcus Setchell, he might be watching this, told me that the Royal College of Obstetricians and Gynecologists has moved from a very posh building in Regent's Park down to the other side of the river, not far from London Bridge. And they are sharing a college now, the midwives and the obstetricians. Yeah. So, maybe that culture. I mean, the other thing that I've seen in my career is really dysfunctional departments, just as you say, where the consultants literally won't speak to each other. They're battling each other, and their individual battles is definitely to the detriment of the patients they look after. And also makes it very difficult for junior doctors. I mean, how do you think, I mean, those are kind of interpersonal problems. How do you think we could deal with those?
Well, with difficulty. I mean, my career has been full of cases, mainly unpublished, because they're all dealt with in private, or disputes between doctors leading to hospital disciplinary proceedings and people being sacked and moved on and so on. Often extremely talented people, but the an inability to agree with colleagues or a department where that has happened needs sorting out. I mean, if you have two pilots on the flight deck who squabble and disagree with each other and concentrate more on their unfavorable personal characteristics than actually flying the plane, it will crash. Yeah. And the same really applies in hospitals. So I think some of it's about an era of medicine which I think has passed, namely the hierarchical view whereby the senior consultant was God and the junior registrar or senior house officer was an absolute nobody. And I think we're moving towards a certain understanding that it requires a team of people to deliver medical care to people. And that team consists not only of doctors of all ranks and seniority and experience, but also nurses and actually many other people, care assistants, cleaners and so on. And unless everyone is doing their job properly and with an eye to safety and their own part in producing a safe environment, we will not have safe and effective medical care. So I think it's about time we did far more by way of joint training between doctors, nurses, and other ancillary professions. So they actually practice working together in challenging circumstances. Now, how you do that, you can do that in many different ways. But I do think that it requires, rather than coming out of one silo of education in a medical school and a silo from a nursing school and physiotherapy or wherever, there needs to be a stage in training where everyone is brought together and actually they are assessed on their ability to work together as a team. Because some people actually find that quite difficult. But I think because what I think happens with some the sort of consultant you talk about is they've developed ingrained habits over a lifetime and they've got away with it. And by the time they're senior, people are too afraid to say anything about it. And firstly, that last bit has to change. And there is no one who works as a doctor or indeed in any other part of the NHS who should be so important, so vital that no one dares to pull them up because of their behaviour towards, for instance, a junior nurse. And unless because the junior nurse may be the person who can spot the mistake in the operating theatre, and unless she is listened to with as much respect as the consultant listened to, not necessarily agreed with, then we're in trouble. And I, as a patient, are going to be in trouble. And we all know of cases where that's been the case.
Yeah, I completely agree with that. And the airline business, very focused on safety, of course. They have their training involves not just the pilots, but the cabin staff and the engineers who are, fueling the aeroplane and so on and so forth. I think there's a huge amount that we could learn from them.
But there's a very good course run by British Airways, which I was privileged to go on. And North Middlesex Hospital on patient safety, but it's run by British Airways in their pilot school. And it does cost a few hundred, didn't cost me a few hundred quid, but it does cost a few hundred quid, but it's well worth it. And for anyone who, if only because it means you can get to fly a jumbo jet simulator as well. But actually they bring together the learning they have from aviation and apply it to patient safety. And they actually put people through an exercise of dealing with a medical emergency in an aircraft, which is par excellence something where you need a team effort, often with people you have no idea who they are. Well worth thinking about.
Well, perhaps the Royal Society of Medicine can do more in this arena. It's something we're thinking about. Now, Jonathan Punt, as he says, a former medical expert, and I think he must be a lawyer. He's latterly a barrister.
Yeah.
He's encountered avoidable and repetitive clinical errors. What are the barriers that you perceived to the NHS learning from clinical negligence cases? I mean, these mistakes occur again and again and again. What's the solution to that?
Well, the first is to try and do something about these cases before they become medical negligence cases in the sense of legal proceedings. But before that, we're not going to have learning from incidents unless we free people from the fear of being personally blamed and hounded and whatever because they've made a mistake. And mistakes are made. We need to learn from them. We need people to be honest about them and and that requires people to be candid to the patient and their families. It requires people to be candid with each other, and part of that is admitting that to oneself that it is possible to get things wrong, and then that needs to be reviewed and looked at, not in an adversarial way, but preferably with the patient if still with us, but their loved ones if not, in order to have a such joint effort at making sure these things don't happen again. What happens at the moment is, or happens too often, is that somebody advises the National Health Litigation Authority, now called NHS Resolution, that there wasn't any negligence. And so the case gets full, and they quite rightly wish to save public money. And traditionally, the way that is done is by fighting a case and winning it. But actually, you win a case in court, no one wins, no learning comes out of it. The NHS will still have spent a huge sum in irrecoverable costs in getting that far. A lot of people's time and so on would have been taken up, and all that would have been much better used in bringing people together to do two things. One is to find out properly what had happened as early as possible. And secondly, to provide support to anyone who's been harmed as early as possible. And by support, I mean principally material support. So if people need care, the state, having produced this harm, should provide it. If money is required, then provide it at that stage. Why do we have to wait 5 years for people like myself to earn a living, putting together schedules of damages and answering them, in order to work out what a person needs to put their life back in the rails? We all did that in a trusting environment with everyone working together to provide solutions, both to stop the mistake happening again and to make sure that the victim is properly looked after. I think we would cut litigation. We would make learning much more the priority of the NHS, even than it is now. People want this to happen, but it's not.
Yeah. Well, let's talk a little bit about affordability. David Davies says, as a retiring clinician with 40 years experience in the NHS, it seems to me there's nothing very just about the law as applied to medicine. Or is the law? It's a bit outdated, complex, and needs updating. Can the UK afford the current form? I think the 60 billion pounds worth of outstanding litigation. I mean, what about the sheer expense of it? Isn't that daunting?
Well, Dr. Davis has many good points there. The legal system is a sort of Rolls-Royce way of picking apart forensically what has happened, why it happened, and whether it met a standard of care or not. But where I think, so as a process, it produces an answer for the question it's designed to answer, which is, has there been a breach of a standard of care defined? And if so, what compensation should be given for it? None of that actually, a lot of that doesn't deliver for a number of reasons. One, which is mentioned, is it's very expensive. Two, it's actually quite random because it requires, to be successful as a patient, you've got to have the right expert. Often people's opinions are genuinely divided about whether things should be negligent or not, and it's the wrong question. So I would very much think we should try and find alternative means to providing support for people who have been harmed, while at the same time emphasizing the need to learn lessons. And that's not at all the same as looking to see whether an individual doctor or nurse or indeed an organization was negligent. Things are avoidable, and I think for what has happened, I think, over a number of years is there has been a declining trust in what is still a very trusted profession when it comes to mistakes having been made. I think in every other respect, the medical and nursing professions are highly trusted. But I'm not sure it's yet fully accepted that they are open and honest with us when something's gone wrong. Many are, don't get me wrong, many are. And when that happens, you'll find when people are given proper explanations, when they're treated with respect, when everything is done to help them, they're far less inclined to want someone hung, drawn and quartered because of the mistake that was made. And they're far more likely to want to participate in an exercise which might prevent this sort of thing happening again. but the system is too complicated. But actually, we are dealing with complicated things. But we need to produce people with the skills to sort out these issues at an early stage after an incident has happened. And if possible, to avoid having to bring in lawyers in terms of negligence action, regulators in terms of disciplining people, and even worse, the police in relation to potentially prosecuting people. With that structure is far too much in evidence as being the predominant factor in these cases, rather than what I've suggested. But what I've suggested only works if the medical profession, the nursing profession, and the health service generally acts in a way which maintains or at least restores the trust that the harmed patient and their relatives had before the incident, so that they still trust what will happen, and they will only trust that if they feel they're not being deceived, and if they feel they're being offered meaningful help.
There's a question relating to, do you think that some of the sort of cover-ups that occur relate to the worries about the damage to the reputation of the institution? And there's a reference made to, you know, famous hospitals like Great Ormond Street and some of the recent issues from there. That's one question. And then the other thing, Robert, is that Jenny Vaughan, who's been a great advocate of David Sellew, who of course went to prison for gross negligence manslaughter. I mean, her maxim is learn, not blame the doctors. And I bet a lot of the doctors listening to this will say, you know, there's too much blame on behalf directed towards the doctor, and not enough from learning the lesson from what's gone wrong. What are your thoughts about those two things?
Well, Jenny is, of course, right. We do have to remember the place of the patient, or where the patient has died through avoidable injury, their loved ones, or in this discussion. And if we're to say that we're not to blame people, which I think is absolutely right, the more we seek someone to blame for something that has happened, which is always oversimplistic in the medical context. It's never really one person. You look at the David Sellew case, the Barwell Garber case, there's a whole concatenation of circumstances that brings about something that shouldn't have happened. And just blaming an individual and thinking that solved the problem doesn't. And that's in answer to an earlier question, is I think a lot of the time why no learning comes out of an incident, because someone is blamed, file closed, no one goes any further than that. So we do need to step back from that. But if we are to step back from that, patients and their families need to know that there has been accountability in some form. And in my view, accountability in this arena is actually the acceptance of responsibility, which is different from accepting, like, I was responsible with my team, whatever it is, for what had happened. It's our responsibility to put that right. And we are determined to put that right, because we didn't want this to happen to you. We want to put it right. And we're really sorry it happened. What can we do to help you? Can you please help us put this right? Now, you can't do that if there is a cloud hanging over someone's head because the police inspector is next door viewing the records to decide whether you can be prosecuted for manslaughter. It's the wrong end of the stick. Now, I think there will be cases, there will always be cases where some form of sanction, even criminal sanction, may be appropriate. But in the vast majority of cases, that's not true. But we say we have to start with a different way of dealing with things than we currently have. And that was Jenny's question. Can you remind me what the first bit of that was that I probably haven't answered?
Actually, I've forgotten what it was myself now. So, there's so many questions here. I'm reading them frantically as I'm listening to you talk. But maybe I'll remember. Hugh Wilkins says, could Sir Robert discuss the evolving views on the pros and cons of registration of NHS managers? You know, I mean, that's another culture problem, isn't it? We've talked about midwives and obstetricians, but I tell you, there's a battle between the managers and the doctors, which is ongoing as well.
Well, I mean, firstly, I know lots of doctors, and probably many nurses, would like to do without managers altogether. But it's a very complicated business, and I think increasingly we do need, and we have needed for some time, specialist managers. There may be doctors, maybe nurses, but people who are properly trained in modern management and leadership. And but the problems I discovered at mid-staffs were largely due to, frankly, incompetent leadership, well-intentioned people without necessarily the capability or the competence or the resource to provide a caring and compassionate and safe service. And one of the issues, if I go back to Bristol, where I had the privilege of representing the chief executive of that trust, who was, in addition to being the chief executive, he was also a consultant radiologist. And he ended up in front of the GMC for professional misconduct because of his leadership of that trust in relation to cardiac surgery on babies. But if he hadn't been a radiologist, that wouldn't have happened. And I think, firstly, that was a case which might have deterred a lot of doctors from actually becoming senior leaders. I don't know if that's still the case. But actually, it means that people from different backgrounds aren't on the same playing field when they sit around a board table and are discussing matters for which the board might end up being accountable in relation to patient safety or issues like that. I think that there are cultural issues there may be cultural issues between midwives and obstetricians. There are also cultural issues between the frontline doctor actually doing the work and their leaders. And it's often, clinical directors are often described as going over to the dark side, aren't they?
Yeah.
And I think that there needs to be a change. Firstly, I think that the medical regulator ought to think about stepping back from actually investigating matters of the activity of a doctor in management. The second thing, I do think the time has come, and I think many managers, leaders agree with this, where at least senior leaders, board level leaders, should be on a register. And being on a register would bring with it a requirement to have certain types of training. It could produce a common set of values, which I know exists anyway, the values you're meant to follow as a leader in the NHS, but it would actually put some more structure into that. And I think when it came to discussing tricky issues around the table, the medical director, the nursing director, and the chief executive, everyone would be on the same playing field when it would come to a matter of regulatory oversight. So it wouldn't be one person in respect of whom there'd be very little accountability, dealing with two people who might carry quite a lot of accountability. So that would be my solution. And I think I said in the mid-staffs report that the matter of regulation of managers should be kept under review. I think the time has come to do something about it. I don't think it will be hugely expensive. I don't think you need to have the panoply, of the GMC. It could be a simpler thing. We're not talking about so many people for a start. But I think it would also give managers a professional status for them to consider themselves as professionals with an ethical code in the same way as doctors and nurses have to. And I think that's really important.
That sounds a brilliant idea to me. I mean, as a urologist, you know, the British Association of Urologists and the RSM, always give a plug for the RSM, meeting and talking to my colleagues supported me through my career, and you know, I'm sure that hospital managers would benefit from the same sort of structure. There's a question here from a coroner, so we better answer that because we'll be in trouble if we don't. Sarah Jane Richards says, as a coroner, I've inquested hospital-acquired MRSA deaths and I've as unnatural deaths. Should the same yardstick be applied to hospital-acquired COVID-19 deaths? And I suppose, you know, the COVID care home issue at the beginning of the pandemic, we could also talk about that, Robert. What's your tricky question?
Well, I think it's a very tricky question for which we'd need more. I'd need to know the precise facts of individual cases. I mean, when we look at the COVID issues generally, right at the beginning of the pandemic, not a huge amount, not enough really was known about how to deal with it. And I'm sure mistakes, things seen as mistakes in retrospect, were made, which would have resulted in people contracting this horrible disease in hospital, whereas probably now people know better how to do it. We know, don't we, that there have been shortages of PPE and the wrong PPE and things that don't fit. Sometimes it wasn't there at all. some of that, it seems to me, is almost inevitable in an emergency. I mean, we can say, and it may turn out to be the case, that there should have been better planning for all this. But it's, and that we will have to see in due course when things have, if they ever do, settle down. But yes, I can envisage circumstances in which hospital-acquired COVID could be the result of something that was actionable. But I think it would depend very much on the individual circumstances of the case. And because we're dealing with a disease that we now know is developing all the time, and it was clear the precautions you might need for something which has a certain level of transferability and infectability may be different from what is now happening, which seems to be several factors easier for it to be transmitted. So I don't know the precise answer to the case, but I do hope that we don't end up with a lawyer's banquet on this at the end of the day. I fear we might, because actually we need people to be feel free in an emergency like this to devote themselves, often at their own risk, which is what's been happening in the NHS, to their patients without a lawyer leaning over their shoulder, in my view.
Yeah, there's another care home question actually from Carol Munt. There are 99 plus questions here, so we're not going to get through them all. This is a world record for us in conversation. Robert, congratulations. So Carol Munt, thank you, Carol. People in care homes have suffered as a result of restricted visiting because of COVID, and relatives appear to have no say in the matter despite ongoing campaigning. What would you recommend as a solution to that?
Carol is a fierce advocate for people in care homes, and we should all be very grateful to her for that. Actually, before we deal with the relatives of people in care homes, can I start with the people, the residents in the care homes themselves?
Of course.
And I've often said, and I say this as chair of Health Watch England, that we should start from the presumption that the person who should make a choice about whether to have visitors or not is the resident. It is that, and I'm assuming a resident who's mentally competent. I'll come on to those who aren't in a moment, but those who are competent to make choices should be advised of what the risks are, and if they want to take the risk involved in seeing a relative, they, in principle, should be allowed to do so, subject, of course, to the risk, protecting others from the risk of harm in them doing so. How that plays out in different circumstances is different, and I absolutely understand that in some care homes, visiting safely for other people is difficult. But the same applies to people who don't have mental capacity to make decisions. There, you've got to make a decision for them in their best interests, but frequently the best interests of a 95-year-old in a care home may be to see their family, because that's all they live for. They would see no point, many people, in living if they can't see their families. And so why aren't they being allowed to, subject to that being capable of being facilitated? And I understand the difficulties and challenges there. I think the guidance has slowly become more clear about this, but it's still, in my view, hasn't quite gone far enough. But I mean, it is actually the case that even in, I mean, it is recognised that the well-being of people in care homes depends to some extent, in fact, in some cases to a very large extent, on being able to receive visits from their family, and quite close visits at that. And even under our current lockdown, the rules allow for visiting of homes which do not currently have an outbreak of COVID in them. So there are rules and regulations about screens and so on, which are a matter really, I think, for the experts. But yes, I do think that the prescription and of prohibition that many care homes seem to have gone in for is running for safety and putting the safety against infection above all other things, when actually there's a balance to be drawn between the interests of the residents in their well-being and the safety of people who want to be kept as safe as possible. Now, all that is easy, I know, for me to say in general terms. It's much more difficult to put into practice. But the starting point should be that people in care homes are entitled to be visited by people of their choice, and that should be facilitated wherever that is reasonably possible. And I don't think the guidance quite goes that far at the moment.
That sounds very sensible. You sent me ahead of this webinar, Robert, a couple of cases to look at. And I thought one of the most interesting one was the one from 22nd of March 2002, the severely disabled patient who'd had a tetraplegia following a blood vessel in her neck rupturing. And it leads on to, advanced decisions and the question of assisted dying, which I know is a very fraught one. But do you want to just briefly describe your involvement? Because you were speaking about the NHS.
It was a fascinating but a very sad case of a young lady, from memory, in her 20s, who had suffered as you've described, and the result of it was she was paralyzed from the neck down and needed assisted ventilation on a ventilator in order to survive. And she had her full mental faculties too, and she was a very clever woman. And she decided she didn't want to live under these circumstances any longer, and therefore she withdrew her consent to being ventilated and demanded that the ventilator be turned off and the tube be removed. The hospital staff refused to do that because, well, for all sorts of reasons, but largely I think as a matter of conscience. They didn't wish to set about killing their patient. So she, with her lawyers, went to court to demand an injunction of the court that they do remove the tubes. I had the somewhat dubious privilege of representing the hospital trust in these proceedings, who were supporting their doctors and nurses in their refusal to remove the tubes. And the hearing of the case took place in the intensive care unit. This lady was in her own single room, but in the intensive care unit, around her bedside. And the judge was there, I was there, Mr. Havers appeared for her. And she was examined like any other witness, which was an extraordinary experience. And the press, it was a public hearing, the press were watching proceedings down a video link in a courtroom. And the judge, rightly, in my view, decided that this lady was completely competent. She was taking a choice, albeit some people would not take, but she was entitled to take it. The treatment could not be imposed upon her. And the hospital was actually acting unlawfully and not arranging for the ventilator to be switched off. And the result of the case was that she was in fact transferred to another hospital, which was prepared to undertake this rather sad task. I thought it was actually a right and proper assertion of the right of the individual to control their own body. It wasn't assisted dying, it was actually the termination of treatment, which are two different things. But no one should be allowed to impose treatment on us that we don't want. And there have been subsequent cases in other fields, Montgomery being the principal one, where we are entitled to be told what the choices and options are in relation to treatment. And our choices might not necessarily be those of the doctor, but that's what we need to be offered. And we shouldn't have imposed on us treatment that we don't want. So that was the case. I think the result was frankly a foregone conclusion as a matter of law, but it's not often it's asserted in quite such dramatic circumstances.
Now, I heard a very touching radio program where Celia Kitzinger, Professor Kitzinger, was talking about her sister who'd been involved in a road traffic accident and was left in I think a vegetative state. I'm not exactly sure whether she was totally vegetative or she was severely disabled, unable to communicate her own wishes. And her two sisters were saying that this was a young lady who would not want to have lived in this state. She would want her treatment to have been terminated, but because she hadn't done an advanced decision process, which we could talk about, she's still alive and still, I suppose, suffering. So what are your thoughts about advanced decisions for our audience, and I guess our audience will communicate this to their patients and friends as well?
Oh, and I gather you may have an audience from overseas as well. And I should emphasise I'm only talking about England and Wales, really. Right. But I think that in our jurisdiction, everyone would be wise to have recorded in writing what their wishes are in the event of them becoming unable to make decisions for themselves through incapacity in relation to treatment, and in what circumstances they would wish treatment to continue or not. In other words, it's a development of the common decisions being made and put in writing about not wishing to be resuscitated in the event of total brain damage. It's a challenging thing to ask people to think about. There are forms that can be filled in that allow that to be done. But if I personally have, like all good lawyers, I haven't followed my own advice and I haven't done it myself. But I think I remember my late father was about to go and be operated on by one of your colleagues, not a urologist, but a cardiac surgeon, and he wanted me to draft for him, and I did a form which the surgeon was rather shocked to receive, I have to say. And that brings me to a very interesting point about it. There are people, I know one patient who was badly disabled and made it very clear that she didn't want treatment to take place, life-saving treatment to take place in certain circumstances. And every time she went to her GP, she asked if he had the copy of her advance decision in his records, and he kept on saying no. So she had to give him a new one every time. I think a lot of your colleagues are very reluctant to get involved in this stuff, but it is actually our right, and we should all think about it, because by the time it becomes necessary to think about it, it's too late.
Yeah, of course, at the other side of the coin, actually, I'm just looking at a question from Faye Sandler. Thank you, Faye, for sending this in. She says a concerning issue was brought up regarding vulnerable elderly patients admitted to hospital and provided with do not resuscitate forms to sign. So, they're kind of being pushed into not being resuscitated when...
Yeah. Well, even worse than that is, which was suggested, it happened at the beginning of the COVID outbreak, that in some places, sort of blanket decisions were being put in people's records. But there is, with all these issues, and I emphasise at the moment, I have not told you anything about what I think about assisted dying. What I'm talking about is the refusal of treatment. But if in that circumstance, it is very important that we protect the vulnerable from pressure from people in whose interests it might be that they shouldn't be kept alive, when actually they'd rather be kept alive. It's actually very dangerous to assume what people would have wanted if they could speak, by the way. I remember one case I had of a girl, who was in PVS, and her mother was convinced that she would want the nutrition to be withdrawn and for her to be allowed to die, and said so in several affidavits and so on for the purpose of the court. About 2 weeks before the case got to court, where frankly a decision authorising or approving of the removal of tubes and so on, or this form of treatment, would have been given, a specialist psychologist visited the patient and established a means of communication with her. I don't know whether it was pressing a finger or something like that, and was able to establish through very painstakingly over 2 or 3 days that firstly this lady was fully understanding of her terrible condition, but secondly, on no account did she want to die or be allowed to die, which rather changed the nature of the case. But, but going back to your vulnerability point, people can succumb to pressure, and it is a feature I've observed of people in their old age that they don't want to be a nuisance. Some of them don't want. They think that that's a reason not for people not to receive treatment. And if that's literally their own competent view, then maybe that could be respected. But I think you have to be very careful that when people make those sorts of decisions, that they are doing it because it's what they think rather than because of what other people have told them to think.
Yeah. I mean, we haven't got time tonight, sadly, to go into assisted dying and the charity Dignity in Dying, which is a lobby for that, and the issue of other countries like Australia and Canada, where it's now legitimate in certain cases. But of course, the pressure on the patients to or the individual to do that is a big issue, and how do you protect against that? But I think we might have to get you back to talk about that for a whole hour, Robert. But maybe because we're getting near the end, kind of going back, Alison Macefield says, in relation to staff and patient well-being, do you think we're doing enough now in terms of early mediation and open conversation to prevent a tide of litigation? I have a colleague, Hugh Whitfield, who's been very, very keen on the idea of mediation rather than litigation. What are final thoughts on that?
Thank you. The direct answer to that question is yes, there is no reason why every single medical claim cannot be resolved by mediation, and that is the way forward. And I believe NHS resolution rather agree with that these days. I think we could be a bit more rigorous in requiring that to happen. And I think that mediators should be encouraged to be rather more imaginative in getting people to think about different solutions, which aren't necessarily limited to the ones that are available in court. But if I could end on one point about the support for staff, which we haven't covered, but it relates to COVID. Our support for staff needs to start long before we get to the point of incidents happening or litigation. At the moment, our staff in hospitals in many places are not getting, I believe, the support they need to do their jobs properly. They're exhausted people who've got nowhere to rest. There are exhausted people who've got nowhere to eat or even being provided with anything of that nature. And we should not forget the stresses and strains they're under, and they need more support than I think they're getting. So it's a question that rises at much earlier than litigation, but they do need support as well to prevent things getting to litigation.
Well, I completely agree with that, and I'm getting messages from the teaching hospitals around Wimbledon and St George's, as I mentioned before, that the staff on ITU, the nurses, the junior doctors, the senior doctors are all absolutely worn out at the moment. And I think, the anxieties about litigation will be impacting on them, as well as the fatigue and so on. Robert, you've done a fantastic job for us, as always, great communication. I'm so sorry for the 100+ people who've sent their questions in that we haven't had time to answer them, but I promise you we will look at them and we may come back to them. And I think, Rob, we're gonna have to get you back because, we've only kind of scratched the surface of all these things. The RSM is a brilliant organization. We are, like everybody else, under the cosh because our building's been closed for the last nearly a year now, coming up to a year. So if any generous souls out there feel like supporting the RSM, or for that matter, Robert's Patients Association, thought I'd give them a plug as well. That's another very worthy cause. Your money would go towards us supporting these doctors and nurses and health professionals through this crisis, because we're very keen to do that at the RSM. Two other announcements to make. We've got our immediate past president, Sir Simon Wesley, talking about the anti-vax movement tomorrow. That's at 12:30 tomorrow. Really interesting. Lockdown denial, anti-vax, big issue really in America as well as here. And next Wednesday evening in Conversation Live we have Richard Horton, editor of The Lancet and one of the leading thought leaders in British medicine, again talking to Simon. So please join us there. If you feel generous, send a donation in. And thank you to Robert, and best wishes to your lovely wife Alison, who's working, I think, downstairs in either your study or her study. I'm not quite clear, but Robert, yeah, fantastic. And the work you do on behalf of patients, but also in support of doctors, whistleblowers, and doctors in general across the NHS. I mean, your life work has been so contributory to all of our jobs in medicine. So thank you and good night. Have a great evening, everybody.
Thank you very much.
Bye.